Yes, thank you.
Well, thank you so much, Leonard Silks. It's we're truly honored to have you here with us.
We have two Leonard Silks today.
So I'm simply blown away. This has never happened before. So
I'm very honored. I mean, Professor Emiri is my daddy. Chief Ayorinde is my second daddy. I'm very honored. Thank you so much, sirs. God bless you.
Thank you, Ms.Abiola.
We need all to learn mediation because we don't have courts anymore.
Chief, I was actually saving that part for the last. I wanted us to get right into the thick of it, and now hear your perspective about litigation and the future of litigation as we proceed, vis-a-vis what is going on right now. Yes, so it's rich. Yeah, so I'm so happy to have the two Leonard Silks with us, and I see Anthony Matthews too is here with us.
Hi, Anthony.
So this promises.
Hi, everyone. Hi. Yeah. Good morning from Denver.
Oh, yeah. Fantastic.
Yeah, thank you so much, Anthony, for tuning in. So we'll get right into this. Good morning, good afternoon, good evening from anywhere you're watching us from the part of the world. You are welcome to another mediation session, Hot Seat, where we have Ms. Abiola Abiodun on the hot seat. And as is the usual practice, what we basically do here is to have discussions on contemporary issues surrounding mediation. This is not, it's not like, we don't train for now, we don't teach. We just want to connect with the essence of the mediators to find out how they see mediation and generally the future of mediation in the not too distant future. So we'll start off first of all with Mr. Dari taking Ms. Abiola's profile before we get right into it. Sorry, before you do that, I would also enjoy everyone to please put their videos on mute. And if at any point in time you have any question, kindly indicate by raising your virtual hand or dropping a comment in the chat section. Mr. Dari will be on hand to take it. So we'll get right into it. So Dari, over to you.
All right. Good evening, everybody. Today we have one of our own person in the person of Ms. Abiola Abiodun. Abiola Abiodun is an internationally trained attorney-mediator and a chartered conciliator with over 16 years post-call experience and multiple accreditations from the Lagos Multi-Dock Courthouse and the Institute of Chartered Mediator and Conciliators. She is a certified mediator advocate with the Standing Conference of Mediation Advocates UK. She is also a certified online dispute resolution practitioner with both the International Council for Online Dispute Resolution USA as well as the ADRpoint Europe. She's an emotionally intelligent, effective communicator, trained in emotional intelligence by 6 Seconds International. She's a certified trainer with the IADT UK. That's a London body. She's a fellow of the World Mediation Organization and also a fellow of the Institute of Chartered Mediator and Conciliator. She's also a member of the Nigerian Bar Association, Lagos Court of Arbitration, the Chartered Institute of Arbitrators UK, the Alternate Dispute Resolution Institute of Ontario, and the Alternate Dispute Resolution Institute of Canada. She's very passionate about mediation and dispute resolution. She's a strong believer in delivering results that make a lasting impact. Like she often states, it's not what I do that sets me apart, it's how I do what I do, creating an enlightening and enabling atmosphere for clients to arrive at resolutions and building lasting relationship. Welcome, Ms. Abiola Abiodun.
Thank you so much, Mr. Dari, for the bio. So we'll now get right into it. So, Ms. Abi,
yes,
can you please, let's know why. Let's talk about your journey into mediation. Why mediation? How did you accidentally stumble into mediation, or what happened? What's the story?
Okay, so I'm going to take you back to bring you to answer that question. I relocated to Nigeria in 2012, and I got a job with Chief Ayorinde's law firm. I didn't know what it was I wanted to do. I just knew, I have done this law for a while, and I got a job with Chief. So I got a job as a practice manager / counsel. And if you know Chief Ayorinde's law firm, it's litigation all the way. So I did that, and I just knew inside me it wasn't what I wanted to do. And then after a while, I moved on to, I volunteered with an agency of Lagos State, and then I got into the Lagos State government, and I was in civil litigation. So for me, it was a function of, actually, you know what, let me go back. When I finished law school in 1998, I didn't, when I finished university, Professor Emery is here, in 1998, I wanted to become a human resources practitioner. So I didn't do law school immediately. I took a year off, and then finally I was nudged back into going to law school by Professor Emery, and then I did that. So but I'd always kind of known that litigation wasn't my thing. And when I was in university, there wasn't much else to do apart from litigation. Anyways, fast forward 3-4 years ago, I had a case before Justice Okwesonwu, and she was like, no, Lagos State, everybody is suing you to court. Take this to mediation. That was my first contact with mediation. And the mediator, dare I say, was, it was very, for me, the whole process, because I had been assigned to go to mediation. So I went in, I said, okay, you know what, you don't know about this, go find out about it. So I was well prepared for the matter. And the mediator didn't meet my expectations. So I thought, you know what, if this guy is certified to do this, and I, who have read for about a week and a half, I feel I can do this better. You know what, why not just give it a try? And the rest, I would say, is history.
Okay, now, and how, so far so good. Can you just tell us about your observations as far as the business and practice of mediation is concerned in Nigeria? Let that be the starting point. Because today we're going to be having some conversations that we usually have outside this to bring to fore on issues surrounding mediation. So let's just have what your observation about mediation has been so far, the growth of mediation in Nigeria, and why you think is the preferred means of dispute resolution.
Okay, so the growth. The growth from, if you look at our history in Nigeria, the growth has been, well, it's been enhanced by COVID. The growth has been, I think in Nigeria now, we've had it for about 20 odd years. And it should have taken off more than it has. And I know this is going to lead to another question because this is a conversation we have often. So I think the growth, I feel it's stunted. That's the honest truth. I feel the growth of ADR focusing on mediation is stunted. So I hope that answers your question.
Why do you think it's stunted?
There isn't enough awareness on the benefits and the value mediation brings to both parties. So that's one. Two, a lot of lawyers are antagonistic of the process because they don't understand it. The third one is there's a general misconception that mediation is it's from a weak standpoint. So if I don't have a good case, you know what, then let's settle for the poor cousin, for lack of a better phrase, of litigation, and let's just, I'm going to speak my language now. It's the bear matter. Let's just go there and see how we can manage it. That's my honest opinion.
Okay, now you happen to be a mediator and a mediation advocate. So we're going to go back to the growth of mediation, but let's just take some steps backward and talk about you being a mediator, or rather working with the Citizens Mediation Center. I'm sure that must have given you an insight into the mindset of people when they come to mediate. So let's just talk briefly about your experience with the CMC and what you have been able to observe thus far. Oh, sorry, before you answer that, kindly, if you have any question, comment, or feedback, kindly drop it in the comment section. And if you need to join us in this conversation, kindly indicate by raising your virtual hand, and I would grant you an audience. So please go on, Abi. Let's talk about it.
Okay, so the general, when people come to CMC, and I've worked there for about almost 3 years now. When people come to CMC, they believe they are coming to a court for the indigent people who come in. So they believe, oh, this is kind of like a court, and whoever is attending to me is going to help me solve my problems. That's one. Two, because of the fact that CMC is affiliated with Lagos State, there's a thought process at the back of their minds that is, it's mandatory. Yes, that's the word. It's mandatory. What was the third part? What was the other part of your question, Fama?
Just generally your experiences at the Citizens Mediation Center.
Okay, so to tell you the truth, Friday, I was at work, and I was telling a friend of mine who's a judge. This was about a year and a half ago, pre-COVID, or 2 years ago, that I love what I do. The feeling is exhilarating. People come in and they are broken. When I say broken, you see they are so distraught. And they come in, and I always do a pre-mediation. I sit down, talk to both parties individually. And then I talk to them together, and then I talk to them individually. So I have a clear idea of where we're going. And at the end of the day, they leave with, the amount of prayers. If prayers were money, I'm sure I'll be cha-ching all the way. But there's a huge relief when they're like, thank God we don't have to go to court. Thank God we've sorted this out. Madam, thank you. And it's just a huge relief that the fact that I'm able to help parties have clarity and come to an amicable resolution of their issues. For me, I don't think there's anything compared to it. Actually, maybe eating chocolates, maybe, but that's just a joke. Oh. It's a really exhilarating feeling for me.
Okay, then. Before we take the comment in the comment section, Anthony's hand is up. Let me just let me unmute him and hear what he has to say. Anthony, could you please unmute yourself? Let's hear what you have to say.
Yeah. Hi. Thanks for bringing me up. I'm going to ask the same question I just put in the chat, but Abby, you're in the unique position of being an active mediator, obviously both in Nigeria and in Canada. And I'm just wondering, top level, how do you see that the practices vary? And then on top of that, my second question is, you said that in Nigeria there is not much respect for mediation, and I'm wondering how you see, is that any different in Canada, or do you see the same thing there also? That's my question.
Okay, so that's two questions. So, they're different, totally different. They're two totally different climes. So I would say the practice in Canada, there's a huge focus on ethics. And in Canada, there's actually court-mandated mediation, which is totally different from, well, we have that here, but the procedures are different. Does that answer your question?
Yeah, it kind of does. But I'm very interested also in the recognition of mediation between the two places.
Okay, so in Canada, there's ADRIC and there's ADRIO. That's on the Alternative Dispute Resolution Institute of Ontario and of Canada, same. And I'm a member of both. they're more like a guiding body. They do a lot of courses. They do, you have to go through a certain process to be registered and become a member. There's actually a professional ethics course that is mandatory there. Talking about differences, obviously there are cultural differences because of the different climes we're in. Fortunately and unfortunately, COVID has, created a whole new dimension to a lot of things. So currently in Canada, there's really no, what would I say, brick and mortar mediation. There's a whole lot of, a lot of things are online. There's actually a third lockdown now as we speak in Canada. So if it's not essential, it's not happening. So everything else is, ODR is, at the forefront. But in Lagos, and I speak for Lagos because I live and work in Lagos right now. Lagos, I actually go into work 5 times a week rather. And on the average, I do about 3 mediations a day, depending on the inflow. But actually, let me retract. Before we would do about 3, 4, but now because of COVID, we do 2. But there are times, depending on what's going on, like on Friday, I did about 3 or 4. I did 3.5. Okay. Does that answer you?
It absolutely does. Yeah.
Oh, okay.
Thank you. Very different. Thank you.
Okay. Thank you so much. So, Abby, we're going to have to cycle back and, like I said, it's not every day you get to have 2 learned souls in play. And one sore term that keeps coming up in this discussion on the growth of mediation is the antagonistic nature of lawyers towards mediation. So can you please permit me to just hear Chief Bolaji on this view on the antagonism of lawyers towards mediation?
My Oga.
Yes, then we'll take professors.
Of course, please.
Then we'll take professors' view and see how we can marry it, because let's just try and get into the mindset of a core litigator to know why they are not accepting mediation, more or less. Chief, I don't know whether you can please give us an insight on this. Maybe we should start off with that, sir.
Thank you very much. I think it stems from the training of lawyers. We are basically trained to be adversarial. We tend to quickly look for points to outdo the other side. So that's really our training. So it starts from the training of lawyers. So mediators and the various bodies really have to, if I can use the word, infiltrate the syllabuses of our law faculties and also the law school, that things can actually happen very quickly, safely. Everybody goes home happy from the beginning of a dispute. We are coming to that reality gradually because let's take 2020, practically there was no work, courts were not sitting, COVID, everybody out. After that, we moved on to NSAS. I think practically everybody here know what I'm talking about, the protests, the riots. And to make it worse for lawyers, the High Court in Lagos, which is the busiest of all the courts in Nigeria, got burnt during the protest. And the whole place, I mean, the place is still the same way it was, it's totally destroyed. We start to breathe a bit. The proverbial knee on the neck of practice was lifted a bit at the beginning of this year, but here we go again with the judicial workers' strike. So for the past 5 weeks, nothing has been happening. I will tell you, in the last 1 month, I've had like 4 major instructions, and I've called everybody on both sides to sit in my library and tell them that, look, listen, look at all the books here and all the resources here. There's nothing they're going to tell you in court that I cannot tell you here. So let's find a way out of this logjam, right? And so I think it's mediation, even though traditionally it hasn't been the preferred option for dispute resolution in Nigeria, but it's going to get there by circumstances. The courts at this point are not fit for purpose. I had a conversation with a couple of chief judges last week, and I told them, look, how beautiful would it be if you can make an announcement that the summer vacation for all your judges will only be for 2 weeks. You'll be applauded, right? Because you haven't been working for 2 years and you've been getting paid, right? So even if we had no mediation mentality, we are forced to go into that now. And I can easily tell you, because I'm not only a litigator, I do quite substantial work in arbitration, not as an arbitrator, but as counsel in arbitration proceedings. And arbitration has one major disadvantage, and that is the cost of arbitration. The cost of arbitration is very prohibitive. So after arbitration, mediation comes next. And I think the work you guys are doing, the work Abby is doing, you need to do more of institutional intervention for even the big clients to see that the best way to go is to have somebody, a couple of people, look at it and help everybody resolve their dispute. So my take, without repeating myself, is that institutionally, you have to infiltrate law faculties, you have to infiltrate the law school, and you have to take advantage of the not fit for purpose position of the courts at this point, right? You know, I mean, I'm a litigator. My eyes light up once I put on my wig and gown and I'm ready to go into battle. I'll be shaking my head and smiling. You know, that's when I come alive. But, my thought is not fit for purpose at this point, right? Even litigators, and that is why we are engaging the court, that they have to come up with a new mission statement, right? You know, if they say the judiciary is the last hope of the common man. Now that common man was the person that went to the court to set fire on it. So that common man doesn't see that place anymore as his last hope. So if mediation is now going to be the last hope of the common man, this is the point. Thank you.
Wow, thank you so much, Chief. Wow. See, Abby, Chief has raised so many conject issues that will be the topic for discussion now. One thing he has said that I want us to start off with now is even the evolution of dispute resolution. Now, commercial and Abby, I need to take it up from here. Commercial activities are evolving. Some 50, 70 years ago, or even 20 years ago, it was okay for you to have a dispute with someone and immediately take the client to court. Now, technology has come into play. Now, so many commercial activities are coming up, disputes are coming up. Now, if you now juxtapose what I just said now with if you juxtapose what so let me just put everybody on mute. If you juxtapose what I just said now with the current state of affairs, would you say that one of the issues we have with the growth of mediation is it might be that the dispute resolution mechanisms are not evolving with the commercial activities in play? More like trying to use a digital mind, no, it's more like trying to use an analog mind to solve a digital problem. I don't know whether you understand where I'm coming from. So
I know this, but
yeah.
Okay.
So two things. Let me first of all get your reaction to what Chief has just said. Then you now take my second question. So all what he has said.
Chief said a lot of things. Which one of them?
The one that struck you the most.
The one that struck me the most.
Yeah.
I think it would be.
Mine is the institution.
The infiltration. I actually, you
Is
know
it
what?
the-
Normally, I
is it
actually
the-
take notes.
Is it the institutional intervention? Because that was one that struck me the
Institutional,
most.
two things
Okay.
struck me. Actually, three things struck me. So institutional intervention. So let me address that first. So now I remember when I was in my first year in university. Well, you know what? I remember how I even got to becoming a lawyer when I was about 3 years old or 4 years old. I was a chatterbox, and my dad was a lawyer, bless his soul. My mom is a lawyer. And it was just a function of, oh, she's a little chatterboxer, the lawyer, she's definitely going to be a lawyer. So now there wasn't much of a guidance counseling process. So it was just filling a JAM form and going to school. Now, when I was in school, I was blessed to go to one of the best schools in Nigeria at that time. And dare I say, it's still a very, very recognized institution. I went to Lagos State University, Ojo. The lecturers were actually very hands-on. They were passionate about their classes. I don't know if that's the same thing now. Now, when I was in school, it was either you become a lecturer or you go into litigation. No, really, my daddy is here, Professor Miri SAN. I didn't think at that point, then we used to look at lectures like, okay, brown shirt, starched tie, So I didn't think I wanted to ever be a lecturer. And litigation, we'll see how it works. But there wasn't guidance. So when Chief talked about the institutional intervention, it's not just the universities. I think mediation I personally believe, and Fola, you know this, that mediation should be a culture, is a mindset. So we should go back to primary schools or secondary schools, and it should be inculcated from there. So when I'm going to become a doctor, I have a mediation mindset. When I'm going to become a pharmacist, when I'm going to become a hairdresser, I'm learning a trade, I have a mediation mindset. That way, the cases that go to court really need to go to court. Strictly the cases that need to go to court. So talk less of universities and law schools. It should be across board. So if we could get mediation to be taught and practiced on a daily basis, that would be awesome. Okay.
No, finish. I don't want to break your flow of thoughts. Please continue.
Okay, thank you. So with regards to also the infiltration of mediation, I guess if we do this institutional intervention, then really mediation would be on everybody's mind, in everybody's thought process, in everybody's contemplations. And then that would lead to a mass revolution of the human mindset.
So I need to interject you right there. So this is me playing the devil's advocate now, still within the framework of institutional intervention. Then that means then the lawyers might not be to blame, because a man can only do the best with what he knows. If he knows better, he will do better. So if at the end of the day, from the university down to the law school, we have always been taught to be adversarial. So if we now turn out to be what they taught us to be, so why then would we now attribute the stunted growth of mediation to the antagonistic nature of lawyers? You know, I never actually looked at it from this point until when Chief said it. We say, okay, fine, lawyers are antagonistic of mediation. Yet, do they know any other thing apart from litigation and advocacy? We learned mediation as a skill. It was not taught to us in school. So if at the end of the day, you want to cut a tree and you're starting from the branch without taking it from the root, can they then be blamed for it?
Okay, so I agree with you. I agree with Chief. However, having said that, you are a lawyer. I am a lawyer. Dare is a lawyer. Mr. Sani is a lawyer. Professor Emiri is a lawyer. So it's a function of, and I'm sure there's so many other people I can't even see here. I know, you know, there's so many other people who are lawyers who are here. It's a function of, in my honest opinion, you choose the path. You choose. My dad was a lawyer, and my dad went to Ife. My dad was, he went to court occasionally, but he was more of a solicitor. So would you now say that because we've been taught a certain, we've been taught, yes, but we actually have the choice. We have options. There are lawyers who, as I said, some people like my dad was a solicitor. There are lawyers who are company secretaries. There are lawyers who are, I mean, in-house counsel. There are lawyers who just do advisory. Not every lawyer has a litigation mindset, but even the parties. I had parties come in on I think it was on Tuesday, and the guy came in. I was, you know, pleasant. Good afternoon. Yes, how can I help you? You know, ground rules. These are the ground. You know, the whole shebang, did the whole thing. And he said, when you finish talking, we're going to court. So now, if his lawyer had told him, mediation will solve your problem. You can take the horse to the river. You can't force the horse to drink. I don't know if I'm answering your question, Falang.
No, you are.
You know, talking
You are.
So it's a function of, you have to decide, you know what, and Chief said something. He said arbitration first. I disagree. Mediation first. If we can't mediate, then we can take it to the different other options.
Why
now, court is
first?
Or negotiation
or
first.
Mediation.
What?
Okay.
Yes, depending on, you know, what the structure around whatever it is. Right? We can negotiate, we can, you know, but court is not the first port of call. It shouldn't be.
Okay.
You know, so back to what you were saying about lawyers, it's here. Oh, I want to charge my client. There's a joke we all know, and there's a joke of the guy finished school and he says, oh, Dad, that file that has been there for 20 years, I finished all the matter. I wrapped it up. I got judgment, blah, blah. And what does his dad say? That file is the file that is feeding this family. So now that mentality, and I think there was a time you and I had a conversation with another colleague of ours, and he said, oh, that actually is, it happens in their climb as well. You know, so even if they teach you, in Yoruba, they say when they teach you, I don't know how to say it well, when they teach you, you will reteach yourself.
Okay.
So that you are fit for purpose. Because what we as lawyers should do, and that's another thing that struck me in Chief's conversation, was it's important to be fit for purpose. It's extremely important.
So what's your own understanding of being fit for purpose?
So
within the framework of this discussion anyway.
Yes. So right now, I posted something yesterday, 5 weeks and counting. I spoke with a friend of mine and he says, oh, I have to lay off staff. You know, I might actually be looking into coming to talk to you so you can teach me how to become a mediator. And he's a lawyer because the courts are shut. And even when they were open, the aftermath of SARS and everything, COVID, the process isn't what it used to be. Even what it used to be wasn't what it should have been, because we have dockets that have 40 cases. How much can one judge do? You know, I don't even want to open that kettle of, that's a whole kettle of, you know, it's a whole different kettle of worms.
Okay. Then.
You know, so if to fit for purposes, to me, what does your client want? What is the best alternative for your client, or best option for your client? And we always have to put the time value of everything into consideration. Okay. So my post yesterday, let me just finish. My post yesterday was, if you have just instituted an action in the court, something along those lines, you're on a long thing, because we all know how it is. As I'm talking to you now, Supreme Court is giving 2024 dates. So if you are thinking that your matter is going to get to Supreme Court and you have just filed now, that means you are looking at 2027. That is if things happen within a year or within 3 years in the High Court. And then, of course, you know how we do. We first go to Court of Appeal on an in-course application. Then, you know what I mean? You know how it is, Fola. And most of us here know how it is.
Yeah, I do. And you see, this conversation is hydra-headed. And we're first of all looking at it from the perspective of lawyers. But before we go down that lane, we have a professor here with us. So let me just ask, let me find out from him, within the framework of institutional intervention and the growth of mediation and the antagonistic nature of lawyers. I would like to hear his premise on it, to know whether indeed we lawyers are just working on our default setting, or whether we need to probably just go back and retrain lawyers. So, Prof, please, on the discussions thus far, can we please hear your thoughts on it, sir? On what has been said so far?
Very well. I would. My network may not be very good. I just stopped in a friend's place so that I hear you loud and clear. Take part in this. Yeah. But I'll say this very well.
Thank you.
Now, I think to start with, we have to interrogate the training of lawyers. The very first law subject the law students take, which we call legal method, the first thing we teach them is called IRAC, which is
okay. I think we've lost Professor.
I think maybe he should switch his video off.
Video off. Yeah. Yes. And Professor, can you please switch off your video? Yeah, to manage the bandwidth. Maybe it might be better.
The schemata, just the.
Okay. Is it from my end? But okay, I got one word Professor said. He said interrogation of the training of lawyers. You know, it's amazing how you come here with so many questions and the guest just drops one word, and that particular word just takes over the discussion of the day. You know, last week was pseudo substantive. Now we're looking at institutional intervention, and then again that now just forms the topic in discourse. So while Prof tries to get back, can you please let's talk about the courts itself, vis-a-vis how it is like. Are the courts, the present day courts, are they actually fit for dispute resolution?
I would say some disputes, not all disputes. Because we have to always have to keep in mind that mediation is not here to take the place of litigation. Mediation, when you know the word alternative is I think for me it's a dispute resolution process, which litigation is as well. So it's a let me think carefully of how to phrase this. Mediation, it's so negotiation, conciliation, early neutral evaluation, arbitration. They are all forms of dispute resolution. Litigation is a form of dispute resolution. And because of what, I think Professor is back. So let me just, Fola, do you want to?
Yes.
Okay. Yes, Professor, can you,
Sorry,
can you
yes.
put up your video? Maybe the bandwidth might be
Okay.
better. Yes, let's try and see if you put, yes, if you switch
Now,
up your video. Okay, let's give
so
it a try
what
now.
I've said is that
Yes.
the first lectures the students have in legal method, we teach them a schemata for organizing thoughts and writing, which we call IRAC. And if you take a look at IRAC, you'll find that IRAC actually does not have a human element. All it has is logic. We teach them in syllogism. So you find that the lawyers come to begin to think that everything must be reasoned. Nothing about emotions, nothing about people, nothing about constructing realities of people. But you see, the truth about it is that every legal problem is a social problem. So until lawyers begin to look at interdisciplinary ways to look at issues, then we'll have problems. Our universities teach just content. No, we don't teach concepts. So there's a need for us to begin to tweak legal education in such a way that lawyers now begin to see themselves as persons who should resolve problems, societal problems, not just win cases and make money. So
Wow. How I wish I could hear the professor. Man, network. And it was actually going somewhere with this point up.
Yes,
So,
interdisciplinary ways of resolving problems.
no. Oh, no. Ways of resolving these problems. Well, Dari, please take down these things. These are going to form good topics for discussion, please.
Yes. Wow.
No, don't worry. Somebody's taking it. Janet, kindly note down all these
first
words.
thing to do is to look at how.
Oh, Prof is gone.
Prof is gone. Okay, so Abby.
The challenges of technology.
Challenges of technology. Yeah. Okay, so as you were saying, can you?
Yeah, we should have online dispute resolution mechanisms in Nigeria, like you have the Alibaba and others. So I think one of the first things you should do as mediators is to establish online against people like MTN and all the other service providers. I think when we start that, then we can say that we're doing something serious. We're taking mediation to a level that would meet the aspiration of the man on the street. I think my network is not so good. I'll talk with you later. I'll go to a place where there's better service.
Okay, then, no problem. Thank you so much, Prof. So before I take Vikrant's comment, then thereafter, Dario will go to the comment section. Abby, can you please finish with that line of thought so I don't break that flow? You were trying to say something.
Where was that?
No, I was asking you about the court being fit for dispute resolution. Do you think they're actually fit for dispute resolution? Yes,
I said for some types of disputes, yes.
Okay.
But not all. Not all. Let me give you an example. I had a matter, and I always use this as a case. I use it as an example. So two parties came. The lady was, she had a lease which she wanted to break because there were insects in her property. So she leased two flats in the same building. Her landlord lived next door. And I just have to say, I actually asked for their permission to use this as an example in view of the confidentiality of the nature of mediation. So she was on the ground floor as her office, and then the top floor was where she was living with her daughter. Her landlord, who lived in the next compound, was a widow and had two children who had just gone off to university. Now, she's a caterer. Every time they cooked or she had an event, she would have her daughter take food to the landlord. So she had been living on the ground floor. The landlord, she called him and said, listen, Mr. Landlord, top floor, there was a gorge at the back of their house. So there were these little insects, the little black insects that no one sees, but you feel. And she couldn't live there, so she was living in her office. So she said, okay, I have paid the rent for 2 years. Can you please give me back, and she had spent about 3 months, can you please give me back, 1 year or 1.5 and take 6 months for all the wahala, whatever. And he was adamant, no, I don't have money, I've spent the money. So in caucus, I dug to the roots to find out what exactly was going on. And the man told me, he said, Madam, he said, I like the woman. I like her. I like her daughter. And immediately he said that, I knew exactly his reason for not giving her money back. He said, to tell you the truth, I have the money, I can give her back. But if they leave, then what happens to all the goodies I'm getting? And he was interested in the daughter. And he was about 52 then. And I thought, this girl is probably about 27 or 26 or something. There's a huge age disparity. Anyway, long story short, I talked to him, and they resolved the issue. How? He returned her money. He and a couple of his friends had bought land in that area. So 10 minutes away, a friend of his had an apartment to rent out. So she retained the ground floor. He helped her move to what you want to call it now, to the new place she was going to. And he actually got her a contract in his office. And she ran the kitchen. As I speak, she currently runs the kitchen of his organization. So now that matter, how would it have been handled in the court of law? It wouldn't, I mean, it would have been impossible to get to the root of the matter, which was he wanted to keep them close. He had interest in his tenants, and he was getting comfy with getting food every other weekend. For someone who's a single man who lives alone, I mean, if you put all those things into consideration, how would the courts have handled that particular matter? I don't know if that helps shed light on fit for purpose.
Yeah, it does. And yes, and I intend to expand that narrative. Well, let me just take Vikram's comment, then I'll take that. I can see we have a lot of feedback in the comment section, then I'll move over to you. So Vikram, over to you.
Not just comment, can I ask a question also?
Okay, please, by all means.
Two questions. First, for both of you, why do you do this show at the time that my show happens, so that there's a conflict? I cannot come in on time. That's first of all, that has to be resolved in court or mediation, whatever the method.
We'll mediate on that. We'll mediate on that.
Okay, but in our defense, it's the time.
On that for us.
I know, you choose that time. You choose that particular time.
No, Vikram, you're 4.5 hours ahead of us. You know,
yes.
So exactly. So what we're trying to look at is really the prime time. You know, 5 p.m. in Nigeria. Yeah, 5 p.m. here in Nigeria is a bit laid back or some sort.
Okay.
We tried 12. We weren't getting enough people for 12. So we tried 1, but 5 we seem to be getting between 25 and 30 people. So that was why we actually stopped with 5. Trust me.
You don't want me to come here. You don't want me to come to these shows. That's what the whole idea is.
Okay, for you, we'll make some money.
Okay. The question, Abiola, is that how do we develop a culture of mediation in Nigeria, and how do we develop mediation as a profession, which means moving it away from the courts as a private mediation?
So sorry, before you, can you please simplify the culture of mediation? That's a bit wide. Because I mean, what do you think? When you say use the word culture and mediation together,
you took the words right out of my mouth. I was going to ask him to.
I'm not going to answer that. I'm not going to answer it. You have to answer it.
Okay, then, Abby, over to you. Where is the culture of mediation? That's wide.
Okay. Let's say, how do we develop a culture of mediation around the country? How do we do it in Nigeria as a whole?
Okay, so let me say this, and now I'm going to go back to what Chief had said. He had talked about the Fola, help me out here. He had talked about the intervention in the educational system.
Yeah.
So I had said earlier, I don't know if you were here then. Educational intervention, yes. It's something you have to do daily. It's something we have to. So the syllabus needs to be amended. Further to what Professor Emiri said, I remember issues, rules, application, and conclusion. IRAC, right? There's nothing in there that brings in the human element. So if now we teach it on a daily basis, we have a syllabus for dispute resolution, I think it's not something that's going to happen today. It's something that's going to happen gradually over time. Yes.
Yeah. Why don't you just say it as it is? Lawyers are disassociated. They are desensitized when it comes to issues.
No, I'm answering Vikram's question on how to inculcate mediation as a lifestyle.
Okay.
And I think Vikram knows he knows the answer to this question, but he's just trying to put me in a spot.
No, that's
so
my answer. I want your answer.
Okay, well, that's fine. So I'm giving it. So I think if we try to have it in the syllabus, as opposed to that mindset, for me, it's everything starts from the mind. Everything, and it's sad we don't understand the power of the mind. Do you know? I have been thinking of. I've been thinking of doing something. When you put something, if you focus on something, let's say, for example, now a good example is if I'm thinking of buying a black BMW. Now, all of a sudden, every other car I see is going to be a black BMW.
Yeah,
I was telling my mom, I said, before the way I think now is so different from how I used to think before. Because now I'm listening to something and I'm listening to it with a mediator's mindset. I'm watching a movie and I'm watching it with a mediation mindset. Even in dealing with my siblings, my mom, so there's a book my sister, I read a while back, about 8 years ago, Sitting in the Seat of Observation. I can't remember who wrote it. When you have a mediation mindset, you see things totally different. I don't know how to explain it. I'm sure you can relate to what I'm saying, Fola. When you are looking at it, it's kind of like a bird's eye view. Yes. So it's wider. So you have a panoramic view of whatever it is you're in. If we can inculcate that in everything we do, gradually, mediation will become a way of life to people who are not mediators like us. And thus, the courts will be less burdened. And the truth about it is, when you go to law school or you go to university and do an LLB, the mindset is, I am going to be wearing a wig and gown. And I won't lie, when Chief said, I worked with him for over 2 years. So when Chief said when he wears the wig and gown, I remember the first time I had a matter in court, and I felt like a superhero. But that was as a litigator. But now as a mediator, I feel, I don't feel like a superhero. I feel like I'm empowering people. I don't know if you get the difference between being a superhero and helping people as opposed to empowering people. Mediator Vikram, I'm sure I've answered your question.
You have. It's just that for every time for every statement you make, it brings about hundreds of questions. So you can see me, I'm lost in thoughts right now. So I'll get back to you now. Chief's hand is raised up. So let me just quickly take Professor Emiri. I think Professor Emiri is back before going back to Chief. Prof, can you unmute yourself and let's give it a try and see whether it might be better. You stopped at the part of, you were trying to look at the issue of Iraq. So I don't know whether you can take it up from there. Prof, are you still there?
Oh my God.
Yeah, hello, Prof, we can hear you. Okay then, so no problem. So
let's go on. I think my network is not very good.
Okay then. So Chief, let me unmute Chief. Okay, Chief, over to you, sir. Then we'll take from there. We'll take Pero. Then before we now go back to comments. Yes.
Can you hear me now?
Yes, we can.
Yes. Okay. Again, what I take from all this, you guys are pioneers, and like Abi said, mediation has been around for like 20 years in Nigeria, but it has really taken a backseat because of the institutional gravitas that mediation has not had in the past. And you have a great advantage. It's not going to take another 20 years for this to become a major thing. Your institutions have to be very strong. It is when you have strong institutions that you can now infiltrate the syllabuses of the law faculties, the syllabus of the law school, and that culture that Vikram was asking about comes to be. So that is what we need to do. We need to take it out from the mindset of people that you are going to become a lawyer because you want to go and score some victories in court and become an accomplished lawyer like Professor Mary and other people. I'm not mentioning myself because I'm so strong to become a good lawyer. Right. So we need to institutionalize the practice of mediation. And we also need to learn from what arbitration has gone through. Arbitration today is also becoming no longer fit for purpose. It is only the big clients and disputes that go into successful arbitration. Others can't pay for it. So we need to work out a structure that makes mediation easy, that makes it attractive, and also provides for a living for the practitioners. Because if you're not making a living, you are unlikely to sit down at 5 o'clock on a Saturday evening and be talking about the subject. So you need to provide how to make a living for me, how to make it easier or easy for the end users of the practice. So it's something that is not likely to happen tomorrow, but it's something that can happen fast because the market and the possibilities are there. They're glaring at us.
But Chief, do you think the fire has been ignited?
You see, I'm not looking at a full fire here, but I'm looking at smoke all over the place, right? It's needed. People need it. Even commercial disputes need. I'm looking at a situation whereby it's so institutionalized, even parties, before they get into a dispute situation, they are already appointing mediators to look at points of potential disputes. So you don't have to wait until parties start issuing notices of a fight, right? Once something is going wrong, the mediator comes in. And I think that's the essence of mediation. Thank you.
Thank you so much, Chief. So I will take Payo briefly before we now go to the comment section to hear Abby's reaction to it. Okay, so Payo, can you please unmute yourself? Yes. So please, can we have your feedback or comment or observation on the discussions thus far? Yes. I think I'm unmuted. Okay. Okay, Derek, can you please look at the questions and commenting section? Let's hear Abby's reaction to it.
Okay. Thank you so much, Fola. Thank you so much, Abby. Thank you so much, Chief and Professor. I'm going to quickly go through the comments in the comment section and also ask the questions that have been asked initially, and I would leave the ones that have already been touched on. Yvonne Alejide said, correct, Abby, that mediation mindset is important. Just like we teach children about law and order, it should be law, order, justice, and alternative dispute resolution. Then someone mentioned, Oludari mentioned, for institutional intervention.
Sorry, can we take Abby's reaction to that before we move over to the next?
Okay.
So yeah, Abby, can we have your feedback to what Siobhan said?
That is,
I agree. I think the fact that we say law and order, and we don't talk about the fact that the law itself it's people we're talking about here. It's not just, I mean, I'm looking at my library now and there's books. But the truth about it is we are dealing with people. And when you're dealing with people, there's emotions, there's so many things. So it's important, okay, I'm not going to say that. It's important to have a holistic approach to law, order, dispute resolution. So yes, I agree with Yvonne.
Thank you so much, Abby. So the next question here would be, for institutional intervention, where can we start to educate and enlighten the young ones about mediation? Is it from the home, from primary school, from secondary, or from university?
Sorry, say that again.
So with regards to institutional intervention, it was mentioned that
from the roots, from primary school, from the home actually, because charity begins at home. Because I remember, one day I was thinking back and I'm like, how did I, because for me, mediation, it was like I wore a glove, my perfect size. And Chief and Professor Mary can attest to this. I'm a very easygoing person. I don't like, if there's noise, there needs to be calm around me. I'm a very easygoing person. And not to blow my own horn, but I am. So for me, I was thinking about it and I thought, okay, how did I, get from being in civil litigation to being in mediation? And I just knew there was an unrest in me about how things were being done in the law courts. Now, when you go back to the home, I remember as I'm the first child, and some things always just kind of come back to you. And I would have to say, okay, fine, you know what? This is how we're going to sort this out. This is how we're going to sort this out. And for me, I try to teach my children, let's sit down and talk about it. So we have a State of the Union, for lack of a better phrase. What did I do to upset you? Let's sit down and talk about it. So if everybody practices that, so if I now go out and my mommy did that when I was growing up, and let's say Vikram and I are having an issue, I would automatically, because of how the human mind works, okay, you know what? If this was at home, or if that would now be a part of me, how would I deal with this? Okay, Vikram, you know what? You're upset. I hear you. Let's talk about this. So now that might not be mediation, but we're trying to resolve whatever there is, whatever the conflict is between us. Now, Chief mentioned something about even before the dispute arises. Should I leave that, Paula? And,
no, continue. I like where this is going.
Okay, so by the time you go to, okay, so let me say someone like CMC where I work now. By the time you come to CMC, there's already a dispute. Parties are already vexed and there's a lot of anger. So I have this thing, there's this little boy, I think last year, that says, Mommy, you need to be calming down. That went viral. So that's what I tell when my parties come and I can feel the anger, the venom, the everything. And I just tell them, I say, gentlemen and ladies or whatever, I'm here to help you, but I need you to help me help you. So we all need to do what? Let's calm down. So if you have that mindset, it works. Now, before your issue even gets to conflict, anybody who knows me knows I like clarity. It's good to be clear on the terms of engagement. So let's have clarity. Let's know, okay, so Daria and I were having a meeting. Daria, please let your 4 be 4. Because if it's 4:15, I would be upset. Now, so you would have in mind, oh, I'm having a meeting with Abby, and I want to be there by 3:50, so that, or 3:55. So I'm walking in at 4, and we can shake hands, and everything's going to go smoothly. The same way we can have that with agreements, we could have pre-mediation prior to contracts, so that stories that touch don't happen. I don't know if I've addressed.
Yes, you have.
Okay, great.
Thank you so much. So you've sort of answered the second question already, because basically what I'm meant to understand is that for the general populace, basically, we all need to imbibe that culture, that we need to leave mediation, leave looking for settling of disputes, even before we get to that, going to mediation or having that conflict. We should actually be able to look out for ways we can actually settle this kind of dispute. So I'm going to take a comment from Mr. Sani. He said, it's just a comment. He says, I think mediation needs a lot of advocacy and general buy-in of the populace to be successful. And I know you would agree with that. Abby?
Yeah, I agree. And that's what FMA is doing. That's what you are doing. That's what I'm doing. That's what Fola is doing. But the thing about it is, honestly, we need to stop calling it alternative dispute resolution. It sounds like option B if option A doesn't work. I think it should be dispute resolution mechanisms. Now, it's going back to fit for purpose. When you say alternative, so it's like saying, so it should be a buffet. It should be like a buffet, as opposed to it being, oh, rice is our main meal. However, if you don't like rice, you can try potatoes. It should be, there's rice, there's potatoes, there's, yes. So we should actually have a dispute resolution table where what is fit for purpose is what is used, as opposed to everybody going to court first. And then, because by the time you go to court and then you, I don't even know, our pre-action protocol bundle, I don't know what's going on, because anyway, the courts are not really functional. So that's another story for another day. Because the court referred mediations, that means they've already gone through the process of filing, doing whatever it is, going through that whole hog of filing and getting to court. You understand me? So
yeah, you're very
before you even, so as lawyers, it is our work to say, okay, Yvonne has come to me and Osaritin and her had an agreement. So now I think also the problem with us Nigerians is we don't, which is why there's that thing, waiting lawyer they do self. We don't appreciate what's it called, intellectual work. A lawyer, people will come and tell you, I say, oh, no big will. I'm just going to go online and download something from Google. I have a colleague of mine who had, and I don't have permission to do this, let me just summarize. It was a mediation, she's a mediator as well. And there was a case, a driver brought his former employer to mediation, was asking for damages because she fired him. And he was asking for damages. And he says he was using big words in breach of the contract. She's caused me mental, I can't remember, but it was a lot of, lawyer words. And my colleague said, where are you getting all this from? And he said, oh, I Googled it. So now the average Nigerian goes to Google and reads up stuff on breach of contract and feels, oh, you know what? 5 years of law school, I'm going to pay 100K. No. So they don't do that and then they get stuck. So it's, as a lawyer, we need to, as lawyers actually, we need to educate our parties. And even when some parties will tell you, no, they want to go to court because They don't want to take ownership.
No.
They do not want to take ownership. So they want someone to say, okay, do this. I have parties that come to me in mediation and they say, oh yeah, please tell us what to do. And I tell them no. Now, if I was a conciliator, if I was working with you in my capacity as a conciliator, yes. But as a mediator, I'm just here to facilitate your conversation. Now, whatever it is you agree upon, you both agree upon is what I do. And I don't want to give that speech because almost everyone here knows what it is. You know, but I'm just going to keep quiet now because I could talk till tomorrow.
Thank you so much, Abby. Just to add to when you're talking about us taking away the alternative from the dispute resolution, a couple of people had actually mentioned that you've actually treated it already. So it's like saying, you know, when you mentioned a buffet. So if we keep saying alternative, we make it look like if litigation is the norm, and then it's now a problem. So it's better we take out the alternative out of it. So people know that, look, this is an option. This is not just an option to it. It is something you should do to get you to even look at the issues at hand first before we now move into, if you want to still go ahead and litigate. Okay, so I'm going to take some more questions right now. This is from Abby. Well, this is Anthony Matthews, just saying what I just said now. Calling it alternative leads to the question, alternative to what? And then you are immediately presenting litigation as the primary method. That's just to reinforce what I just mentioned. Mr. Sani also said, well said, Professor, the dissonance between concept, logic, and reality in the practice of law is the main issue. Yvonne also said, yes, indeed. Only mediation gets to the root of the matter. The third neutral facilitator makes a big difference. That is third-party neutral, pomp and pageantry of wig and gown. Abigail Omoboye mentioned this. She said, I respect the law and legal practice a lot. Litigation and all of it encompasses. Here is the point of view. How about we raise lawyers that are more passionate about dispute resolution itself, appreciate or respect law, order, peace, and justice, rather than lawyers that are more obsessed with the wig and gown and the status that has been associated with it. I believe then the utmost duty will be resolving disputes despite the title associated with the method. It is the mental transformation needed. Those in practice presently can lead this change in mindset so that the upcoming ones will not perceive one method of dispute resolution lesser. What would you say about this?
Okay, sorry, before we take that,
okay.
Can I just quickly acknowledge the presence of Honorable Justice Dabiri? She's here with us, and it's not every day you get to have a judge. So very briefly, can I just interject to find out, I don't know, I can't find her here. Let me see. Where, Milord, if you are here, can you please unmute yourself? I can't find Milord here. I thought I could have sworn I saw her for a split second. Okay, so please proceed, Dari.
Okay, I wanted to take Abby's just comment on what.
So once you're done, let's just stop and then we'll go back to the regular questions.
Okay.
Yeah, thank you. So Abby, over to you.
Okay, so so Abigail says raising lawyers that are more passionate about dispute resolution itself, rather than lawyers that are more obsessed with the wig and gown. I agree. So if that goes back to the intervention with the educational system. Yeah, if we could do that, and we have, as I said earlier, dispute resolution mechanisms, litigation being one of them, as opposed to litigation being the main thing. And then if litigation fails, then we can look at all the other ones. We should have a whole slew of dispute resolution mechanisms. And then it's a fit for purpose. You pick, you try this on, until you find what fits. So yes.
So now, something just came to mind now, Abby, and I'd like to hear your thoughts on this. Mediation deals with facts, and I want to lay a premise on that. You agree with me, right? Mostly deals with facts. Mediation mostly deals with facts. Yes, and facts have emotions in play.
Oh, I see Justice Dabiri, he's here again.
Okay, yeah.
Sorry, go ahead.
Yeah. Okay, so let me just quickly take Milord. Milord, we acknowledge the presence of Milord here with us, and I don't know whether you can please unmute yourself. Let's have your take on mediation, on the growth of mediation and the antagonistic nature of lawyers. Would like to hear from the bench what your thoughts on this are. Okay, I think he has unmuted himself. Okay.
Maybe he's not there. I see him, but maybe he's not.
Yeah, no, he's not there. So yeah, so yeah, like I said, I was trying to build a premise. Mediation mostly deals with facts. Facts have emotions in play. Litigation mostly deals with law, and and if you look at if you look at law, it is as it is, not what it ought to be. So in defense of litigation as it is, what do you think? Do you envisage a scenario where litigation and mediation can go together, or do you see one as a precursor to the other?
It depends.
Explain, please.
It depends on the facts of each individual case. Okay. There's some matters. So now the matter that took me to court before Justice Okwesonwo, now that matter, it was a land matter. So what happened in that matter was there were some issues that were resolved at mediation, and then the issues that weren't resolved went back to court. So does that, I don't know if that answers your question. It depends on the facts of the individual facts of each case. There's some matters that, as far as I'm concerned, should not even be going to court at all.
Okay.
A lot of matters.
So in your opinion, do you think mediation should be made mandatory? Personal opinion. Do you think it should be made mandatory?
Yes.
Why? Bearing in mind the issue of voluntariness.
Yes, but if mediation being made mandatory, now it's not. If mediation, I think mediation should be made mandatory because of the perception, the misconception around it. So now I was just going to say, if we make it mandatory, it gives it weight, but that's not what it should be. People need to understand the value and see the value in mediation. Now, making mediation mandatory means you must first go this route. Doesn't mean you have to conclude, but at least look clearly at the issues at hand. And I've found that when people actually sit down face to face and they're at a table and they can look at it, they're like, oh, really? Okay. I didn't know that was this. And that's really what happens when you have issues. There's miscommunication. So what mediation to me, when mediation is made mandatory, or if it's made mandatory, it gives parties an opportunity to clarify. It helps them distill the issues and see everything on the round table and oval table, square table, and then they say, okay, you know what? This is not really an issue. We could settle this, between ourselves. We can negotiate on this, and then maybe there's something that's really substantial that they can now say, okay, we need a judge, or we need precedents to lay a foundation for this.
Okay. So now we have just 10 minutes. So and in rounding up, if you had the opportunity of looking at a looking glass, no pun intended, how do you see mediation in the not too distant future? Then followed closely by the advice you have to the younger lawyers here and those aspiring to take mediation as a profession. So let those two questions flow into one another.
Okay, so I think the sky is not even the limit.
We have to start.
As someone I know.
Like you say in the building.
Woo! Oh, so we can't finish in 10 minutes then.
No, finish in 10 minutes.
Okay, great.
Go.
Someone I know says one day that I need glasses when I look at the future of mediation. I think that we've not even scratched the surface, or we're just scratching the surface, as to what the possibilities are endless for mediation. But it's important we are careful that mediation does not become like arbitration. For those who are looking into starting mediation, I would say, anyway, if you're a lawyer, then you know that the reading never stops. Please do this. Get into it. Get accredited. Get the books. You need to read. Mediation is hands-on. Mediation is practice. So, there's actually something, and I think I would like Chief Ayarinde to comment on this. When they say, oh, are you in practice? Lawyers, Fola, now, that means, are you in practice? Are you in courts? Now, it's with everything. It's not just, I don't know, I think lawyers have kind of, just converted that to a legal terminology, for lack of a better way of putting it. If they say, are you in practice? That means like, are you court going? But in mediation, we practice daily, and we're dealing with people as opposed to dealing with the law. So mediation itself needs and must be practiced. So if you're thinking of going into mediation, you need to get accredited by a very good organization or facilitation, mediation house, or whatever they're called, and practice. And you also need to read. There's always something to read because you're dealing with people. So, Fola knows. Fola inspires me when it comes to reading. You're always reading. Because when you think, okay, you know what, I'm okay, then something happens and you have to read. So please, get on the bandwagon. There's space for everyone.
Interesting. Thank you so very much, Ms. Abi. I want to take time out to say, so do you have any final words before I give the vote of thanks? So I can acknowledge everyone here that has joined. Final words.
Well,
though it has been a very interesting session. It's been quite an interesting and insightful session.
I wish I was on the other side because I have so many questions. I'm really humbled. Thank you. For everybody who I spoke with, who I didn't speak with, who I sent a message, who came, thank you very much. Mediation is I will steal Fola's words. I eat, breathe, live, and drink mediation. I blink mediation. For me, it's the way of the future, and the truth is the future is now. It's important to be future focused because Yoruba people say when you go to court, you can never come back as friends. And there's an element of truth in that because it's adversarial. So I tag myself a non-adversarial lawyer with a mediation mindset. So there's so many things, there's so many things we can do that we don't have to resort to court. Not taking away from the position of litigation or what it does, but there's so much we can do, as people, as lawyers, as mediators, as mediation advocates. There's so many things because we're not even taught those things when we're in school. There's mediation advocacy. If I had known, I would have been a mediator for close to 20 years now. But the Chinese people say the best time to plant a tree was 20 years ago, and the next best time is now. So for those who haven't joined the bandwagon, please do. And mediation is the way of the future, and the future is now. Thank you to everyone.
Wow. and very powerful way to end this. So I want to take a special time out to thank everybody that has joined us: Chief Bolaji Ayorinde, Professor Siri, Honorable Justice Dabiri, Emiri, Honorable Justice Dabiri, Mr. Valentino Buru, Mr. Kisoya, Yvonne, Mrs. Sage. This has been a very, very interesting.
Mrs. Sage is here.
Mrs. Sage is always here. So now the takeout from yes.
Well,
Thank you so much. Now, the takeout from today is that Chief has raised so many valid points that he has raised the bar in terms of the kind of questions we'll be asking now. I've taken out some certain questions that we can't even finish under 1 or 2 hours. So I would enjoy everyone to please join us same time next week, Saturday at 5 p.m. We'll be having a Queen's Council, which is the equivalent of an SCN, to be here with us next week, Saturday, in the person of Andrew Miller, to discuss contemporary issues surrounding mediation. And I look forward to seeing everyone here. We have the chairman here of ATMA. We also have Mrs. Okono here with us too. Thank you so very much. And we look forward to seeing everyone next week, Saturday. Vikram, thank you so much. Thank
what
you.
You just said is,
what
you just said, Fola, that you're seeing everyone, and here you keep putting the same time for Saturday. It's amazing. Everyone except Vikram.
Okay, I think we'd have to probably look into that and take it like an hour to behind and see how we can accommodate Vikram and others with different time zones. So thank you, everyone, and we look forward to seeing you next week.
One minute, Fola. I just have to say, my mom is here. I don't know if she's logged on. Mommy, thank you. My mom is Ms.Abiola Abiodun. And, I
tried to unmute her, but she didn't say anything. Mommy, thank you so much, man. God bless you.
Mommy, no.
Yeah.
Mommy, thank you for logging on. Thank you to everyone. Thank you so much as usual. You guys have been awesome. And I didn't think I could do this, but I don't know.
Yes,
did I do good?
Oh yeah, you did very well. And like I always say, it's uncurated, it's unscripted, it's not a training, it's just for us to basically connect with the essence of what we do. And for the benefit of those that came in a bit late, this will be posted, it's live on YouTube. Kindly subscribe to our YouTube channel, Fortify Mediation Academy, to watch the recordings of previous occasions and previous sessions, and I can assure you, you will have a thing or two to take from it. Thank you so much, everyone, and we'll be here next week, Saturday. Goodbye.
Thank you.